Welcome everyone. Thanks a lot for staying with us. You're watching Plain Speak with me, Shivani Gupta. Since 2014, the opposition has often alleged that the central government led by the BJP has been attacking and undermining Indian institutions, including the judiciary. The same allegation has been hurled at the centre yet again. A big row has erupted over the appointment of former Supreme Court Judge Abdul Nazeer, for example, as Andhra Pradesh's new governor. While the Chief Minister of Andhra Pradesh, Y.S. Jagannath Reddy, welcomed the move, saying it's his privilege to work with Justice Nazeer, the opposition has cried foul over the appointment. Congress, AIMIM, TMC and the Samajwadi Party have called the appointment of the justice a damage to judicial independence in India. They claim this posting is a reward for the justice who was part of the 5-judge bench that unanimously paved the way for the Ram Temple in Ayodhya. Justice Nazeer is in fact the 3rd judge from this 5-judge bench that gave this Ayodhya ruling to receive a post-retirement appointment from the government. But is that the full truth? And is this the first time a judge has been appointed in a role by the central government immediately post their retirement? We'll break those details down for you in just a bit, but the larger question is, as Prime Minister Narendra Modi recently said in his thundering speech in Parliament, is the opposition repeatedly raising questions and undermining the very institutions they claim to protect just because they're out of power? By making this charge against the new AP governor, has the opposition proved Prime Minister Modi and their critics right that they criticize everything and just because it doesn't go their way? We'll take that question to our guests in just a bit. But first up, a quick background of what this row is all about. Remember, President Droupadi Murmu announced the appointment of governors to as many as 12 states on Sunday. Ex-Supreme Court Justice Abdul Nazeer was appointed as the Andhra Pradesh governor. As I mentioned, State Chief Minister Jagannath Reddy has welcomed the appointment, saying he looks forward to working with Nazeer. But a lot of the opposition parties raised questions citing the Ayodhya order and alleging, quote, quid pro quo. BJP has slammed the ecosystem court, saying that this appointment is actually a bid to uplift minorities in India, that too in high positions and high-ranking positions. A quick breakdown of what all the opposition has said. They have in fact launched an all-out attack at the centre, saying that Ranjan Gogoi was the first one from this bench who was made a Rajya Sabha member. Now Nazeer has been appointed as a governor. They linked it to the Ram Mandir verdict. The BJP has hit back and said that this is not the first time that a judge has been appointed as governor. So what is the problem? And we'll break down similar instances in the past. The Congress is alleging that the centre's move will weaken public's belief and faith in judiciary. The BJP has slammed the opposition, saying that actually it is their polluted mindset which is being exposed. The opposition has also accused the centre of setting a wrong precedent. On the matter of precedent, of course, we'll get you some facts, but the BJP is saying that this elevation is being opposed because he was part of that Ram Temple verdict, just because they don't like that verdict. The opposition has called Nazeer's appointment damage to judicial independence, targeting the Congress, though the BJP said governors don't represent any political party or ideology. In other words, then what's the big deal? So let's take a look at Justice Nazeer's landmark verdicts. He was part of the bench that upheld the centre's decision on demonetization. That's a very recent one, recent judgment by the Supreme Court. He was also recently a part of the bench that said that no additional curbs can be placed on the speech of lawmakers alone. He was part of the bench that paved the way for the Ram Temple in 2019. That's the big one that's been quoted by the opposition. But are they forgetting the rest? For example, Justice Nazeer was also part of the bench that held that privacy is a fundamental right and an integral part of the right to life and liberty. And very importantly, he was part of the minority opinion in a split 3-2 verdict on triple talaq case, in which he held that the practice was legally valid. Now, that's not a view that the government of the day shares. And it's not like this has started only recently. Here are some instances where the Congress had given government posts to judges immediately after retirement, because the timing is also coming under question. So Justice K.G. Balakrishnan retired in May 2010. That's when the UPA was in power. He was appointed as chairperson of the NHRC in June 2010. So very quickly. Justice A.K. Ganguly retired in February 2012, appointed as head of the West Bengal Human Rights Panel in March 2012. Justice M. Sharma retired in September 2011. He was actually cleared as the Vansadhara Water Dispute Tribunal head 4 months before the retirement itself. Justice L.S. Panta, retired in April 2009, was appointed as the chairperson of the NGT in 2010. There are examples from Congress rule of governors being appointed, judges being appointed as governors post their retirement as well. Whether such postings should be allowed and if there should at least be a cooling off period post-retirement, these are subjects that have been long debated in India. But what do the rules say as it stands? So there is no law that restricts a retired judge from holding the post of a governor particularly. In fact, in 2021, the Supreme Court had refused to fix a cooling off period for judges as well. In 2014, again, the SC said that we cannot fix a cooling off period for judges to take government jobs. But there is a one-year cooling off rule for retired bureaucrats that exists in India for IAS, IPS and Indian Forest Service officials. The big question we debate today, there is another attack coming in on the judiciary, on its independence, the way the institution is functioning or not. By doing this, is the opposition proving its critics, including the Prime Minister, right that they criticize every institution just because they don't like what's going on?
People who have served in the apex judiciary, should they be accepting such post-retirement sinecures?
जिन्होंने आपके बारे में फेवर किया, उनको कुछ ना कुछ फेवर आप कर रहे हो.
Congress party itself had laid down the convention of giving positions to the retired judges. Some allegations on such appointment, I think it is not proper on the part of any political party.
अगर कोर्ट में फैसला पक्ष में नहीं आया तो सुप्रीम कोर्ट को गाली दे, उसकी आलोचना कर दो.
Joining me on the show, Gopal Krishnan Agarwal is the BJP national spokesperson. Ujjwal Nikam is senior Supreme Court advocate. Anup George Chaudhary, senior Supreme Court advocate as well. And Dr. Satish Chandra is former justice from the Allahabad High Court. And Dr. Chandra, I want to begin with you. How do you see the criticism that has come in line? Not the first time that these appointments have come under the scanner, but particularly one judgment of the former justice is being quoted. Is this a fair criticism of the appointment?
No. The Constitution itself is providing under Article 155 for the appointment of the governor, that is by the President. President means by the government. This is a political appointment. And 157 article says that he must be only a citizen and plus 35 years of age. That's all. This is the qualification. Nothing like that he should be a judge or he should be a politician. This is total discretion of the government to appoint anyone. And in the past, we have seen the Fatma Bibi, M. Fatma Bibi, in 1997, she was a governor in the Tamil Nadu and continued till 2001. And on 1st July, she resigned when there was the arrest, arbitrary arrest of Karnanidhi at the midnight.
Yes.
And another, this O.P. Verma, who was a judge in the Kerala High Court, he was also appointed as a governor of Punjab during the regime of Mr. Vajpayee. And P. Sivam, the CJI, who was also appointed in 2014 as a Kerala governor. And now the Abdul Nazeer is also appointed just after 40 days as a governor of the Andhra Pradesh. So this is the sequence, you can say. The examples are available, but here in this case, today's case, cry is this, that just after 40 days from the retirement. Secondly, he has given the judgment of the Ayodhya. This is coincident, or maybe this one award or this opposition is saying this is award. But fact remains that he is a person, citizen of India and about the 35 years of age, and there is no bar for his appointment.
Overall, would you say, overall though, if I broad base this discussion, overall, would you say that there is a problem when retired judges are appointed as governors or any other government role? Or at least should there be a cooling off period which the Supreme Court has deliberated many times?
Madam, there are post-retirement, there are two types of posts. One is the judicial post or quasi-judicial post. For example, the head of the tribunal.
Yes.
Various tribunals are there. National Company Appellate Tribunal is there, Ashok Bhushan ji is there, and National Human Rights Commission. The chairman will remain the Supreme Court judge. So it is already written in that provision is there. And also the state governments, the National Human Rights Commission, there are very, very various posts where the quasi-judicial nature is there. Can be appointed immediately, but question arises when there is some political post like the governor.
Okay.
So this is the only discretion of the government. And cooling period, if it is there, it is better for the governmental posts, political posts, but not the for judicial posts.
Right. Okay. Let me also open this up to some of our other guests. Anup George Chaudhary, is this showing a little bit of bankruptcy of the opposition when they raise these questions over the character of a judge? I can understand you don't like a judgment, but it's very unfair to Abdul Nazeer, for example, to somehow suggest that his judgment was biased because there's a post-retirement post. That's effectively what it means. This isn't the first time this has happened. This isn't going to be the last time. So what has changed?
You know, I think don't add political color to it. If something had happened before which is wrong, it still remains wrong. It was the leader of the opposition, the late Mr. Arun Jaitley, who was a very renowned lawyer, has been a law minister. When he was in the opposition, he clearly said, his statement is there, that post-retirement appointments of judges should not be made. Because that conveys a pre-retirement benefit that to occur and helps them, and independence of judiciary is lost. So this is their own BJP's very reasoned judge. You know, he was a class lawyer and a very good person, and he raised his objection. So it's now coming back to the BJP. I don't say anything personally against Mr. Nazeer. And what the gentleman now was saying, nothing is illegal. We are not talking about illegality. We are not talking about illegality at all. Why give a chance for anybody to say something like this? Because again, politics is politics. Fingers are going to be raised, and the embarrassment is to Justice Nazeer himself. Previously, what happened, Justice Sathasivam was appointed as Governor of Kerala, as Chief Justice of India to go as Governor. He is actually lowering his protocol. As the Chief Justice of India, he outranks the Governor. But then after retirement, he goes there as a Governor.
Okay.
There may not be anything in that at all. But what is the question of? It's a question of perception.
Okay, but can I just come in on the issue of perception? Is this something which is completely breaking protocol from what it was in the past? Let me just quote an example. There is a precedent of something like this as far back as the 1950s. Justice Fazal Ali became Odisha government post-retirement, and it happened within a year of his retirement. So this goes as far back as the 1950s as a practice. Now, if we want to project this practice as a bad, wrong practice, we must come together and actually debar it then.
Yes, absolutely correct. And that's what Mr. Jaitley wanted, to create a atmosphere where everybody agrees on this point. That yes, don't do that, because it gives wrong signals. Even if there is nothing, it gives wrong signals.
But does the opposition have the higher moral ground to raise this objection today? That's my fundamental question.
No, objection every. Arun Jaitley raised it in 12 when he was in the opposition. So you will say why he raised it in 12 and why is the BJP not doing this today? So it all depends. Opposition is going to raise this issue. They are meant for that.
Okay.
Like when Arun Jaitley was in the opposition, he raised this issue. So obviously when the opposition is raising this issue now, relying on the statement of Mr. Jaitley as the leader of the opposition in Rajya Sabha.
Okay, the other fundamental question, okay, fair enough. The other fundamental question I want to raise, and I'll go across to Ujjwal Nikam, another senior advocate, and then I'll give our political representative Gopal Krishna Agarwal an opportunity to respond to all of these points being made. The other issue here today is, Ujjwal Nikam, that while one judgment that Justice Nazeer was part of, which is the Ayodhya judgment, no denying a landmark judgment in Indian jurisprudence, is being quoted as some sort of a reward that he's getting for, the critics are very conveniently forgetting he was also part of the minority judgment that did not agree with the government line on triple talaq legislation, for example. So you cannot pick and choose. You have to see this in totality. Ujjwal Nikam.
Absolutely correct, Shivani. But let me make it very clear at the outset that I am not practicing in the Supreme Court. I am practicing in Maharashtra.
Yeah, I beg your
There
pardon.
are two questions that cropped up for the consideration. The first question that is to be considered, whether there was any illegality in appointing the retired Supreme Court judge as a governor, because the post of the governor is a constitutional post. Now, question number two again, that whether there was any impropriety. I am using the word impropriety on the part of the judge to accept the post, the said post of the governor. Now, you say at present, after retirement, the Supreme Court judge or any judge, he becomes the free citizen of our country. So, he can accept any post if he thinks fit to do and to discharge the work as per the constitutional post. Now, the question number two is whether there was any impropriety. Now, it is for the Mr. Nazeer to consider whether it was improper or proper to accept the post.
Okay.
Now, you say public perception, whatever it may be, I don't want to enter into that political area. But what you have quoted about Mr. Nazeer's judgment, that is in a minority view. And even then, that judgment cannot be quoted as a basis to condemn the government's action or to condemn Mr. Nazeer also.
Okay.
So, what is the wrong? What heaven is going to fall? Even if you consider the foreign country, in US also, the many retired Supreme Court judges are appointed on number of the occasions, on number of the posts. And therefore, I don't find any fallacy either in appointing the judge or to accept the vote. It's a question of public perception. What my other panelist friend has rightly said, it is the question of the public perception. And it is for the concern, because I am working as a special public for number of cases and I am a free citizen. I can accept and I can defend the criminal, but I don't accept the criminal's matter because I would like to have the public perception to be toe with my line.
Okay, fair enough. You drew a comparison about US. In US, actually, all Supreme Court judges' appointment in itself is very political. So, their system is remarkably different than what we are following right now. I think Mr. Chaudhary wants to come in and say something. Yes, Mr. Chaudhary, a minute I'll give to you before Mr. Nikam can respond.
Yeah, I'll just point. Ujjwal Nikam talked about the fallacy and correctness and illegality. That's not correct. That's immaterial in this case. Nobody is saying there's a fallacy. Nobody is saying there is an illegality. If this has to be by a consensus, it should come under the Judges Service Condition rules by all concerned, because it sends out a wrong message. Now see, the media takes advantage of it. The media is referring to some judgment by Justice Nazeer. That's not fair to him.
No, we are not referring it because we like it. No, sorry, sir. These are statements that have come in from political parties, quoting the Ram Temple judgment.
No, even without political parties, I read the Indian Express also, I read the Times of India in the morning. It is being quoted not that it's something spoken by the opposition or somebody.
No, it has.
News.
Sir, it has.
So
maybe they didn't have this by the time the paper was printed last evening.
Also.
We have responses on camera by opposition leaders where they've said that this is because of Ram Temple. They said this for Ranjan Gogoi too, by the way.
I'm not saying that you have done something wrong. What I am saying is media will publicize something which helps them to publicize and attract. And there is the question of TRP ratings as well. There's nothing wrong with that.
I'm not sure how TRPs come into
but
here.
Why give a chance? I'm only saying this.
That's something. Sir, I'm sorry. I'll defend the media here with all due respect. We've only quoted what the opposition is saying here. They should have been mindful of not dragging a former Supreme Court judge into what judgments he or she has given. But let Mr. Nikam... Okay, yes, please finish quickly.
Can I?
Yeah. Who wants to... Gopal Agarwal wants to come in. Yes, please come in.
I would like to underscore 3-4 points that are very important.
Yes.
The opposition is opposing the appointment of Justice Nazeer on the governorship. I just want to say, are they opposing because it is not constitutional or not? So it is clear that it's a constitutional appointment. Constitutionally, it is not wrong. Second is, are they opposing because of his judgment on Ram Janmabhoomi? So they should now tell that are they against the building of the Ram Janmabhoomi temple, are they opposed to that temple at Ayodhya? They have to underline that also. The third is there are ample precedents which you have also underlined that there are ample precedents where the ex-justices were appointed to various constitutional posts by the UPA, Congress and other government in the past since the independence. So the thing is where and even the process had been challenged that the justices, ex-justice should not be appointed to any constitutional post. In the court of H.L. Dattu, where the court, Supreme Court has bench of H.L. Dattu ji has said that no, there is no restriction on ex-justices not being appointed to the thing. So the important point is it is not unconstitutional.
Okay, but can I come in, Mr. Agarwal?
Last one point also is important. All the 4 points are very clear that it is very well within the system of the government to appoint them. The last important point is the Congress has, with opposition, has the mindset that they have not accepted Modi government's democratically elected government on any of the issues. And this has been underlined at many of their actions. They will oppose, go to any extent to undermine any institution in their zeal to oppose any of the decision of our Modi government. So they will undermine Supreme Court, they will undermine Election Commission, they will undermine other institutions, regulatory organization, everywhere they will say government.
I understand your point, and I've obviously run responses from the BJP to suggest this. But what about the point that Mr. Chaudhary is raising? You and your very eminent leader Arun Jaitley voiced the opinion in Parliament, in fact, over the over the issue that judicial appointments bring in our system. So why is it that you've not taken a stand, that you would not do this?
No, the thing is, there are not only single point issues which the government has to take into consideration and decide. The government, our government, has been empowering people from the communities, whether it is women, Dalit, OBC, minorities, wherever we find situations where we can empower them and bring them to various constitutional posts. Our government is doing it.
Can I take that to Ujjwal Nikam also and then Satish Chandra? In fact, Ujjwal Nikam, the government is saying, look, there are not many minority judges from the Muslim community in the Supreme Court. If anything, this decision should be seen as promoting judges from the minority community and then in such respectable positions as governors.
So what is your question, Shivani?
Is that a fair argument for the government to make, that this should be seen as promoting minorities in India, you think? Or should that be left aside from these appointments?
See, Shivani, let me make it very clear. I don't want to enter into any political area as such. But I must say that it is for the concerned person, that it is for the Mr. Nazeer, has to consider whether by accepting such post of a governor, what public perception will be carried in the mind of public. Now, I am telling you very frankly and clearly, absolutely there is no such thing which is dwelling in the mind of the public at large. But the political parties are making the issue and they are conversing that these appointments are being made just to malign the image of the judiciary in the eyes of the public at large. So it is for the political parties to consider that by making such wild allegation, are we not unnecessary bowing down or hammering not only Justice Nazeer, but also to the common man of the country? Because what common man faith and belief that is being betrayed, that is the most important danger thing to a democracy.
Okay. Can I ask you very quickly, before I take a final comment from Satish Chandra also, do you personally, as an eminent lawyer who's functioned in the system for many decades, believe that there should be a bar on judges becoming governors? Or at least a cooling period?
Already this has been referred to the Supreme Court and they have given the judgment H.L. Dattu.
Fair enough. Fair enough, but we can always revisit it. In India today, we are discussing, and Ujjwal Nikam was part of my show when we were discussing, for example, the collegium system and how the judges are appointed and things like that. We can always, debate. But let me take his opinion. I take your point, Mr. Agarwal. This has been deliberated. I've mentioned it. in the Supreme Court, they have repeatedly said that there cannot be no bar and no cooling off period. But Ujjwal Nigam, can I press you for your personal opinion here?
Yes, there should be a cooling off period. In fact, there should have some rules and the regulations. So the central government should consider it very seriously. That is my personal opinion. Because unless, you see, such rules are being made, the public outcry or the public criticism which is being canvassed and propaganda by the political party will damage the whole institution as such. And the common man faith also will go in the government. That is the potential danger. So I think government should consider that there should be some.
But here's the tricky part. The government cannot do this, right? Ultimately, this will have to be something that the Supreme Court also in a judgment approves of. The government cannot do something like this. It's been already with the Supreme Court. Justice Chandra, I have only about 30 seconds left. Your opinion on whether this is a needless debate that comes up because of politics of the day, or whether there needs to be a rethink in this issue.
Madam, today's debate is that Mr. Nazeer had given a judgment pertaining to Ayodhya, and after the retirement of 40 days, he was appointed as the governor of Andhra Pradesh. But fact remains that before him, there were so many judges who were elevated to the post of the governors. They were appointed to the post of governors. So had they given the judgment in favor of the government, that is another issue which can be discussed and can be examined by them. But fact remains that whatever judgment he has given, that is the judgment of the Supreme Court, not of Nazeer.
Fair enough.
After deliver, it becomes the property of the Supreme Court. And secondly, I would like to say there are 28 tribunals under the control of the central government, and there are 5 or 6 posts more like the Human Rights Commission and this SABI's appellate tribunal. So from where you will bring the judges? Because there is a provision that only the High Court judges or Supreme Court judges will be appointed as chairman or the member.
No, I asked that specifically when it came to the appointment of a governor.
There are too much tendencies there in the tribunals.
No, you are absolutely right. There are tribunals, quasi-judicial tribunals where you need retired judges. But what about governorship? I've run out of time, though. I do thank all of our eminent guests and panelists for joining us. Whether this is a debate that has only cropped up because Ram Temple verdict is one that has still not been swallowed by most.